small businesses have a significant part of our nation's economy, and everybody knows they're so important for our nation's health. According to a March 2010 Small Business Administration report, firms employing fewer than 500 employees employed over half of the private sector workers in 2006. Additionally, small businesses can be drivers of innovation and economic growth as well. It's interesting to note, though, that both of these facts, the 500 employees, the over half of the growth, et cetera, have been true under the existing regulatory system that has been in place since 1980, when the Regulatory Flexibility Act was enacted. Despite the testimony that we will hear today about how the RFA has been ineffective at stemming overbearing regulations that stifle small businesses, the fact is that small businesses have done well in the almost 36 years since the RFA, as amended in '96 by the Small Business Regulatory Enforcement Fairness Act, has been in place. I'm concerned that the bill that is the subject of today's hearing, H.R. 527, the Regulatory Flexibility Improvements Act of 2011, may be a solution in search of a problem. In fact, it's very similar to a bill introduced in 2003, apparently to get at the oppressiveness of the Bush administration's regulations on small business. In the written testimony, the three majority witnesses all cite the same study by Nicole and Mark Crane that claims the federal rulemaking imposes a cumulative cost of $1.75 trillion on the nation's economy. Mr. Schull will one of our witnesses, will rebut the particulars of that study, I'm sure. But I will note that the Center for Progressive Reform, among others, has debunked the Crane study thoroughly, noting the study does not account for any benefits of regulation, and it's relied on suspect methodology in reaching its conclusions. I would like to ask unanimous consent, Mr. Chairman, that the CPR report entitled Setting the Record Straight, the Crane and Crane Report on Regulatory Costs, be entered into the record.
Without objection.
Thank you, Mr. Chairman. Unfortunately for the proponents of H.R. 527, the Crane study appears to be the only statistical evidence that they can cite or can be cited in support of this notion that regulations impose undue cost on small business. While I don't dispute that regulations can impose cost and that cost-benefit analysis is a valuable tool for ensuring that agencies promulgate good regulations, I remain skeptical as to the degree of the purported problem as the proponents of H.R. 527 suggest. I also take issue with the notion that the federal regulations are to blame for what remains an unacceptably high unemployment rate. If anything, current employment problems can be traced to a lack of adequate regulation of the financial services and housing industries, which allowed for reckless private sector behavior that just about everybody recognizes as the cause of the Great Recession, the 2008 financial crisis, that most severe economic recession since the Great Depression. It was the lack of regulation that hurt us, not regulation. Almost anything that can stand, anything can be stand to be improved, and I'm open to suggestions on how we can improve our regulatory process, particularly how it relates to small business. But H.R. 527 proposes some needlessly drastic measures that threaten to undermine public health and safety and waste public resources. I point to three particular examples. First, I'm concerned about the requirement that as part of the regulatory flexibility analysis, agencies must consider the indirect effect of a proposed or final rule. Although the bill attempts to put some sort of logical limit on this requirement by specifying that the required analysis be restricted to those indirect effects that are reasonably foreseeable, that qualification is insufficient. Asking what is indirect and what is reasonably foreseeable still requires highly speculative analysis. Forcing agencies to devote limited staff and resources to engaging such type of unwieldy, indeterminate, and speculative analysis, which would constitute nothing more than a guessing game, is a waste of taxpayer money, putting government workers and more to work on issues that are not going to result in an aid to our economy or small business. Second, I'm troubled by the repeal of agencies' authority to waive or delay their regulatory flexibility analysis in the event of an emergency. If we are truly concerned about flexibility in the rulemaking process, then at a minimum, agencies ought to retain the ability to respond to an emergency. The rationale for repealing this emergency authority is not clear, at least not to me, other than as a general attack on rulemaking. Third, I'm concerned that H.R. 527's look-back provision is simply a backdoor way for special interests to undermine existing health and safety regulations. You know, the Clean Air Act was passed and the EPA created by a Republican president, Richard Nixon, one of his crowning achievements other than making the trip to China. As Mr. Schuller notes in his written testimony, agencies would be forced to re-justify longstanding rules ensuring the safety of the air we breathe, the water we drink, the food we eat, the products we buy, and the places we work. Rule that most Americans support, and rules that need to be maintained for the health and safety and welfare of the American public, which is part of the government police powers that need to be maintained, enforced, and strengthened for the benefit of all. I am open to ideas on tweaking the regulatory process in modest ways to make regulatory compliance easier for small businesses and perhaps finding better ways for small business to provide input to specific rules. As drafted, though, H.R. 527, a redraft of a 2003 law that's dusted off with a 2006 law, now introduced as a 2011 law, simply goes too far and hasn't changed much in 8 years. Thank you, Mr. Chairman. I yield back the remainder of my time.